Marketing with Higher Level, and we're going to spend our morning with Sherry Rhodes. She's going to be telling us about the marijuana in the workplace and kind of the new laws and what's coming into effect. We will try to get back on track after our small mishap. So Sherry, I'm going to pass it on to you to kind of give yourself a short introduction, just since we're kind of running 30 minutes behind here, and get started this morning.
Okay, thank you, Erin. And if anybody has questions, if we can still do that as you have them.
I can't hear you.
Now you can't hear me?
You're muted.
I'm not.
All right.
Can you hear me now?
And if everyone can please mute themselves so there's no feedback, if you can make sure that everyone is muted, that will really help.
Can you hear me?
Yes.
Okay. And if anybody has questions as we go along, can they still ask?
Yes.
Okay.
As questions arise, they can chat in the chat box, and
okay.
I don't know, Sherry, if you can.
Okay.
Can you see the chat, Sherry?
I'm sorry?
Can you see the chat? If not, I can relay the questions to you.
Let's see. I can now.
Okay.
I guess.
All right. Well, thank you for following us, and let's get started.
Okay. Good morning, everyone. I'll just tell you a little bit about myself, only in the sense that I have practiced law now for more than 43 years, and I tend to concentrate in employment and business law. And in particular, I have done a number of these kind of meetings to kind of educate employers and employees about the change in the law. And what's important here, especially for employers, but employees as well, is that this new law takes effect on January 1st of this coming year, 2020, and it only affects the use of cannabis. And it allows for the recreational use of cannabis outside the workplace. What that means for employers is you still can have a reasonable drug-free workplace policies. And one of the first things you should do, if you haven't already, is look at what policy you have in place. What this law will not allow is that the random drug testing for cannabis. It does not affect your ability to have random drug testing for anything else, should you choose to do so, but only for cannabis. So it's important to keep in the back of your mind that this law really only applies to cannabis, and you need to see how that may affect your current policies and if you have a need to change them. As long as you apply your policies in a non-discriminatory manner, you should be okay. But let me explain what this policy does allow the employer to do. Because the law in the state of Illinois, now as of January 1, will allow for recreational use of marijuana, one of the things you cannot do is to refuse to hire somebody or discipline or terminate somebody for their lawful use of cannabis outside the workplace or when they're not on call. It does not change your ability to take disciplinary action or termination. If somebody, I'm sorry,
guys.
That's not me.
I hope you're not hearing us.
I am.
Oh no!
You should mute.
Let's see. We should put a mute.
Can everybody still hear me? Can you hear me fine? Can you hear me? Okay.
Yes.
What this law will allow the employers to do is to take disciplinary action or termination if an employee is either in possession of under the influence of, impaired by cannabis while at work or on call. And at work means on the job, whether it's at the job site, whether they're out seeing a customer or a vendor, in the parking lot, they're at work. So if they are under the influence or impaired by or in possession of, you can take disciplinary action. Now, in possession of is pretty easy. Either they have it or they don't. So the issue for the employer is, what does it mean to be impaired by or under the influence of? And that the law is very broad about what that means. All the employer has to do is have a good faith belief and that the individual is under the influence of or impacted by. And it says it gives examples of specific articulable reasons or symptoms, and such as, this is not exclusive, but it certainly gives you the broad idea of what might be included. It could involve a change in the speech of the employee, a change in their physical dexterity, their coordination, their demeanor, they're engaged in irrational or unusual behavior, their disregard for the safety of themselves or for others, or when they're involved in a workplace injury that causes injury or serious damage to property and or machinery. Now, if somebody has speech problems all the time, then just say, oh, there's a speech problem with this person. No, that's not anything unusual. But when somebody has some sort of behaviors that are demonstrable, that you have a good faith belief that they may be under the influence, that gives you the basis to take some disciplinary action or some corrective action. But it's also important to know what this law specifically provides and how you can get in trouble as an employer is, if you have a good faith belief that somebody is impacted by or under the influence of cannabis, you need to give them a reasonable opportunity to respond to your belief that they're under the influence. And the law doesn't say what that reasonable basis to respond is, but my suggestion is that you have a policy that both requires your supervisor who's observed the employee and believes they're under the influence or impacted by, to document what they saw or heard this employee do that made them form that belief. And it tells the employee, when the supervisor says they have a good faith belief based on X, Y, or Z, the employee has the opportunity to respond and says, oh, no, I'm just really overly tired because we have a new baby and the baby was up all night. You know, whether you find that as an acceptable explanation or not, that's your decision. But the law requires you to at least give that employee that opportunity. So having the supervisors document what the good faith belief is based on and giving the employee the opportunity to respond to it are going to be the two most important things you can do as an employer, along with training your supervisors about what that means, because that will also go to the idea of the good faith. And what this law also is unique about, saying not only if they're at work or on the job, but if they're on call. And by on call, it means they are on 24-hour notice that they could be called into work. So they cannot be impaired by or under the influence or in possession of cannabis during that on-call period. I see that one of the questions is, what about if it's a Department of Transportation safety sensitive position? How would that supersede the law? This law is, I think, was somewhat hastily written, and there's going to be a lot of questions to yet be resolved. There is a provision in the law that says if there is a state or federal reason, if you as an employer are subjected to a state or federal law that requires an absolute zero tolerance, that law is going to trump, that you must comply with the federal law, or if you have a federal contract or you're subject to potentially losing funding from the federal government or the state government because you don't have this zero tolerance. If you are, however, a state employer who does not have one of these governmental contracts, the fact that you have a safety-sensitive position is not an exception to the statute as it's now written. So you really need to know whether you have any federal or state contracts that have specific language that requires you to do something different than this law. And why this comes about is Illinois has made it lawful to use recreational marijuana as long as it's not in the workplace and the individual is not impacted by or under the influence of marijuana in the workplace. It is not a federal law, however, and it's still a federal violation to use recreational cannabis. It's not a law that's being enforced particularly, but the importance is you're dealing with Illinois state law. And somebody had raised a question before the program about what about state lines and having a business both in Illinois and Missouri, and job candidates going to work over state lines. Well, if the employee is employed by you in a location in Illinois, whether they cross state lines for their job or not is irrelevant. They're a state employee. They're an employee in the state of Illinois, and they are entitled to the protections and the obligations of the Illinois state law. But again, Missouri may be different in terms of the recreational use, and they're going to have to be in compliance when they're there. But as far as your employment relationship, your Illinois employees are going to be governed by Illinois law. Somebody's raising a question about safety-sensitive drug test is dictated by the government. Hang on a second, I can't see all of it. So as to what is required to be tested, so it would be superseded based on what you stated in my mind. If you are it's not just that the government has a standard. The question is, are you a federal contractor? Do you have a contract with the government? Do you have a financial contract, or are you, the U.S. Department of Transportation has rules, Illinois Department of Transportation has rules. Those will supersede this recreational use law, at least as the law is now written. A lot of this is going to have to be worked out with the courts, because as I said, there's a lot of law that's not really talked about today in the laws that now exist. But the one thing that I can tell you for sure is that you can no longer do, or as of January 1, will not be able just to do random drug testing as long as you are obligated to comply with this statute, at least as to cannabis. So for the employers that I've been talking to, they will have, if they're having pre-employment drug testing done, they are not testing for, or at least not receiving the results of anything for cannabis. It does not affect your ability to test pre-employment or post-employment or random, does not in any way affect any other kind of drug. And why it's important to you to know that you can't be just pre-employment testing for cannabis, although unless you're under one of these exceptions under federal or state law, it's because in Illinois there is a Privacy in the Workplace Act, which says an employer cannot take disciplinary action or refuse to hire somebody who engages in lawful conduct outside the workplace. So somebody comes in and applies for a job, you can't, oh, I saw on Facebook last week that you were at a pot party. If you decide not to hire somebody because of that, and you're bound by this law, that's going to get you into trouble. And that law provides for rights to the employee who didn't get hired or got disciplined, including damages and attorney's fees. It's just something you want to avoid. But again, we're only talking about cannabis. So in terms of what I think the best practices are for employers with this new law, know what your obligations are, check your policy, make sure it's compliant with this law. If you don't have a policy, you need to have one. It doesn't have to be terribly complex, but it's got to set out that you're not going to randomly drug test for cannabis, but you can take action if you have a good faith belief that an employee is under the influence or impacted by or in possession of cannabis or any other unlawful drug or alcohol, that matter. If they are at work, on the job, which will include in the parking lot, going to see vendors or customers, or they're on call, which is defined by the statute as having 24-hour notice that they may be called in to work. Next important thing is to train your supervisors, who are going to be the front line for seeing that somebody is under the influence or impacted by, and teaching them how to document their good faith belief. And again, the law's examples are very broad and will tell you, give you an idea of the kinds of change in behavior that adversely affects an individual's performance in the workplace. Now, so again, review your existing policy or create one. Train your supervisors on what these cannabis-related impairment signs may be, the procedures that they're to follow, making sure you have documentation. Make your decision. If you have an employer with a good faith belief, you are an employer rather, with a good faith belief that somebody is impaired or under the influence, one of the questions I've gotten is, well, should we have somebody tested once we have that good faith belief? Well, the problem right now with that is there's really not a good test for whether somebody's under the influence or impacted by cannabis in the workplace, because as most of us know, if they've used it recreationally and appropriately days or weeks before, it may still be in their system. I know that there are probably a lot of companies working on developing tests, but as of yet, there isn't really one. So decide whether, if you think somebody's under the influence, do you want to have them tested? Now, if you're testing because there's going to be a whole lot of other drugs, that's one thing. But because there's not a really good test to tell you whether somebody was under the influence or impacted by cannabis, like we do have for alcohol, I personally think that's not a good use of an employer's money. Give me a second, I have a question. It says, am I understanding correctly? Is pre-employment and random drug testing for cannabis not allowed after January 1, 2020? Yes. That understanding is correct. However, post-accident, it would be acceptable. Yes, that is also correct. And is there a good faith belief of employee under the influence in the workplace? Would drug testing be allowable as it is in alcohol? Yes, it's allowable if you have the good faith belief and you want to go have the individual tested. How accurate those tests are for determining whether they were actually impacted or under the influence in the workplace is going to be a factual issue. But as long as you have a good faith belief, you can then test for any of the drugs, including cannabis. As I said, you train your supervisors to help them understand what a good faith belief is before disciplinary action is warranted. That's very important, and to have a procedure for the employee to be able to challenge it. It doesn't have to be a terribly complex procedure. It's not a full due process or criminal hearing. It's an opportunity for the employee to know what the basis of the supervisor's belief is and to give their response as to why that employee believes that is inaccurate. But other than that, as long as you have that in your policy and you follow that procedure, you should be in good shape. Oh. Did I lose? Uh-oh. Oh, sorry. I lost myself. I'm not very, very techy, so please forgive me. I do also want to point out the recreational use of marijuana is not the same as medical marijuana. If somebody has a prescription for medical marijuana, there may be a question as to whether they qualify as an individual with a disability under the Americans with Disability Act or the similar state law. That's a whole different kind of thing. And even an individual with a disability only has to be accommodated to allow them to be able to perform the essential functions of their job. That doesn't necessarily mean smoking or ingesting marijuana on the job if it's going to influence them. But that's a different day, and that's a much more complex. I just want you to know that recreational and medical marijuana aren't necessarily the same. If somebody telling us that since there is not a THC level test to determine the amount of influence an employee may be under, why would you send the employee for the test? Well, that's what I said. I don't think until they come up with a reliable test that's necessary, unless you're testing for other things as well. If you have a good faith belief that they're under the influence of cannabis or some other drug, then you test. That's one thing, because you may find out it's something different other than cannabis. But if your belief is that they're only under the influence of cannabis, your good faith belief and the opportunity for the employee to respond about that belief before disciplinary action is taken is all that is required under this law, not testing. Then I have a question: is the employer protected if the member tests positive for THC following an accident, even though they used days before on their own personal time? How do we determine that? That's the problem. I mean, whether it was in their system and they had an accident, that's going to be on a case-by-case basis. If you have a good faith belief that that was part of the reason that they got into the accident, that may be a basis for you taking action. Okay. I'm not sure I understand this question. It says broad stroke tests make sense. Oh, I hope that means just a good faith belief and giving them the opportunity. So, do we have any other questions? Erin, are you still with us?
I am, yes.
Okay. Do we have some other questions that our audience wants to talk about? Okay, I got the question again about what do we do when we have employees crossing state lines for work? Again, if your employee is based initially out of Illinois, that's where they're employed, you still have the obligations to comply with the state law as it relates to that employee. So if that employee has crossed state lines and engaged in conduct that you believe is good in good faith, means they were under the influence, again, you have to give them, you have a good faith belief, you give them the opportunity to respond to what that is before you take any disciplinary action. The fact that they have crossed state lines or not does not eliminate that responsibility for you or your obligation to comply with the state law. They may also, however, have laws in that state they have to comply with, just like anybody else who just happens to be in that state. Right. Now, the next question I have is, what if they smell like cannabis and eyes are red, but they deny they used, and can they be sent home without getting into trouble? Well, the question is, if you're just saying they smell like cannabis and their eyes are red and it's not affecting them on the job, I'd be cautious about sending them home. Is there some other behavior other than having the red eyes and the smell of cannabis? Because they could have been wearing the clothes who knows when. Can we still do pre-employment drug screening if we don't test for marijuana? Absolutely, you can. Is there any restriction on the discipline used if the employee is under the influence, or is it just based on current policy? There is no restriction on the discipline. That's in accordance with your company policy and your discretion. The only thing this law requires is when you have a good faith belief, you have to give the employee the opportunity to know what that good faith belief is before you take the disciplinary action. Now, if you think they're a risk to somebody, you certainly can say, this is your behavior. We're going to send you home, come back tomorrow, and we'll talk about it, about why we think this before you've actually done anything other than just get them out of a situation if you think they're a risk to themselves or to others. Next question is, if I have a contract with a local township jurisdiction and they prohibit that's not specifically provided for in the statute, so that's a question that's going to have to yet be resolved. Primarily, the exceptions are federal, and there are certain state restrictions like the DOT laws or the contracts. I'm not sure. I guess I need to look at the specific, but as a first blush reaction, I would think that your contract with the local township is not going to get you exempted from compliance with this law. Here's the question. How does prior marijuana conviction of a felony nature impact the employer to hire? Well, I'd say we need to look at the particular, whether that conviction affects any other aspect of your job, because generally in the state of Illinois, hiring or refusal to hire simply because there is a felony conviction is not appropriate. Now, if it's then that person is going to be put in a job situation with where that might affect your ability to do the work of your company, may be a different issue. But as a general rule, I'd look at the actual qualifications of the employee. If they had a conviction and they served the time or paid the whatever reparation they were required to pay, look at what is going on in that individual's life now. Next question. Most of those would be expunged from the record anyway, though, right? I know there is a huge move under this law to expunge convictions for marijuana use. Whether that's the felony convictions or not, I am not sure. But I know that there is going to be a lot of those convictions are being expunged, so they would not be appropriate. And as you all know, just because somebody might have been arrested, that's not even something you can consider either. Our company, it says, our company has a last chance agreement for drugs. Should they test positive, they are offered the opportunity to go to rehab. Should they choose to go to rehab, they are allowed to continue their employment under specific terms. If drug was marijuana and they were under this agreement after January 1, would that be a company's choice to remove that agreement due to marijuana becoming illegal? That's an interesting question. I've not had that one raised before. But I think if you already have a last chance agreement in place, that last chance agreement stands. That there's nothing that would prohibit, in my mind, you're needing to vacate a last chance agreement with that employee. But again, if the conduct would be use of marijuana as a violation of the last chance agreement, and it happens after January 1, you're going to have to follow the law, which is that you have to have a good faith belief and you have to give them the opportunity to address what your good faith belief is before you could terminate them for the violation of the last chance agreement. Next question I have is, we are currently using a 6-panel test that includes THC. Will we need to get a different test that do not include THC as an option? Or can we use the test and not take into account the THC? What I don't know who the company is and whether they do the testing themselves. But if they have somebody else doing the testing, I would suggest that you ask the laboratories not to report back to you the THC levels if they test for it, because then you have eliminated an argument that, yeah, you had it, and yes, you really used it because you knew what it was. If you do your own testing, I think it needs to be eliminated as a category. If you're talking about pre-employment or anything prior to this law going into effect, we do the testing ourselves. Okay. Hang on a second, I'm rereading your question. I would suggest to you, this is the same person asking the question saying they do their own test, or somebody else saying they do their own testing. Oh, same person, sorry. And if you can, if there's another test that you can use that does not include the THC, I would suggest that's what you do, because you can, if it's in there and you just don't use it, you leave yourself open to the factual dispute from an employee that's saying, yes, you do. If you never get the test results, then there's no way that you could have used it. Would a person who is salaried be considered on call, such an upper management or mid-level position? I don't think, as a general rule, just being on salary means you're on call. I know that there are some upper level positions that you're like 24/7, and I think that's a question that needs to be looked at individually about what that job requirement is and what that employee's responsibilities are. Because this statute talks about on 24 hours notice. If a supervisor or a high-level manager knows that they can be called any time of the day or night, then you might have an argument that that would comply. But I'm going to say that's going to be an exceptional situation, not an everyday occurrence. More questions, ladies and gentlemen? Aaron, are you getting any questions?
I currently do not see any questions.
Okay. Well, if we have no other questions, I appreciate your time and attention. I hope it helped, that you found it useful.
All right, thank you.
Wait, I got another question.
There we go.
What if an employee uses marijuana on break or lunch off the property and comes back under the influence? Under the influence is under the influence. I don't care if they did it a week ago, a day ago, or on a lunch break. When you come, it's lawful for them to use it off when they're on their lunch break and not on the work site. But if they come back and they're under the influence or they're impaired by it, they are absolutely subject to discipline or disciplinary action. As long as you have a good faith belief, that's what's going on. And I would say more than just smelling of cannabis on their clothes. It's the behavior. How is their behavior demonstrative of being under the influence or under impact, the influence of or impacted by? Again, also, if they have it, they're in possession of. Remember, this law talks about you're under the influence or impacted by or in possession of at the workplace. The next question, I got another, we stimulated some questions. If we suspect an employee is in possession, what as a company are we allowed to do to determine possession? I would suggest that in your policy, a personnel policy, you have a statement to the employee that if they have lockers, those lockers are subject to being searched if there's a good faith belief they're in possession. If you think it's on their person, that you will be allowed to ask them to empty their pockets. If they have, you're going to have to determine that based on each individual employer. That what can you do? Or if you believe that they're in possession, you can say if an employee is believed in good faith to be in possession and they refuse to allow the workspace belongs to the employer, the desk belongs to the employer, the lockers belong to the employer. So you should have a provision that the employer may search the policy search those items when they have a good faith belief. If it's on the person, you're just going to have to, whether you have a policy that says if you believe an employee is in possession of, you have a good faith belief, you tell them what the good faith belief is, and they say, no, that's not me. You say, okay, I still think you are. Then you take your action. Again, as long as you have a good faith belief and you give them the opportunity, you can't just say, okay, put up your arms and let me pat you down. That's not what you're going to do. But if you have a good faith belief and you give them the opportunity to respond and you don't get a good explanation, then you can say, okay, you're going home for the day. And you may have a policy that says, and we're going to ask if we can search, and if you say no, that's fine, but that's going to be taken as if you were in possession, and you can still subject to discipline. Every employer should kind of consider what their need is in their company and then address it specifically. But it doesn't have to be a really detailed process with lots of steps. It's just got to be that the employee knows you had a good faith belief, this is what it was based on, and they have an opportunity to respond. And you take the action that you deem appropriate. Because in the state of Illinois, an employer can do something for a good reason, a bad reason, no reason at all, as long as it's not a legally impermissible reason. And under this law, it's not legally impermissible if you had a good faith belief and you gave them the opportunity to respond to what you believe that was. Let me see. If employee is found to have cannabis in possession on company property, the same disciplinary action as per policy. Whoops. Is it correct you only have to give 30 notice to institute? I'm sorry, I'm not sure of the question. The question is from Paul. It says, if you don't have a current drug policy, is it correct you only have to give 30 notice to institute one, 30 days notice? If that's the question, you don't have to give any specific amount of notice unless you have a policy in place that says we won't institute a new policy without 30 days notice, or I have a collectively bargained agreement that controls how much notice. You just have to give notice to the employees that you have a policy so that they know this is what's going to be in effect. Post it on their board where you put up other policies, perhaps. Or if you have a small enough workforce, you can distribute it by email, or by actual paper. Can you do pre-employment drug test for marijuana? Not unless you are under the exception that we talked about for a federal or state contract. Okay. Well, I have a question. Will I please provide a definition of safety sensitive position? I don't have a definition, and I think that depends on the work that you do. But this statute, as it is now written, if you're not under an exception for a state or federal law about, like, over the road drivers, truck drivers kind of thing, simply having what you define or anybody defines as a safety sensitive position does not exclude you from compliance with this law. Okay, the last question I have, I think, is for you, Erin. They want to know if this program has been recorded.
Yes, we have recorded, and we will send out the recording later on this morning.
have a question that says, what if you have a good faith belief that the employee is under the influence of something and you send them for drug testing and it comes back only positive for marijuana? How do you proceed? Well, if you had the good faith belief that they were under the influence, it could have been cannabis, and you send them out to testing to document, and you see that they come back positive for marijuana. You still had the good faith belief beforehand, before you had them tested. It's what I call belts and suspenders. You still have to give them the opportunity to respond to what information you had, the good faith belief on which you base sending them for testing. And as long as you have done that and given them that opportunity, you are in compliance with this law, and you can discipline in accordance with whatever your policies and practices are.
All right, Sherry, I think this is a good stopping point. I think we could probably ask questions all day on this topic. So we definitely appreciate your time. Thank you everyone for joining us this morning as we learn more how to navigate these new changes. We will be sending out the recording so you can look at it at a later date. And please reach out to us if you have any more questions.
Thank you, everyone.
All right.
Have a good day. Bye.
Bye.